So, good afternoon, everyone. Welcome to our virtual class. This is for REM 6201, Law on Obligations and Contracts. And I am Professor Maria Romana Daguio, your assigned online learning coordinator for this course. Okay, so we are now in week 6, and that is Extinguishment of Obligation. So this week, now we are just going to continue class, our discussion with regards to extinguishment of obligation. So we are now in section 2, then 3, 4, and 5. So we will finish discussing the remaining sections on the causes of extinguishment of obligation. So last week, we have discussed about section 1, and that is extinguishment of obligation by way of payment and or performance. So you can extinguish the obligation by way of payment, pagbabayad, or performance, paggawa ng prestation. So this afternoon, we are going to continue that, and we are now in section 2. All right. So section 2 talks about the loss of the thing due, nawala. Okay, so Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it shall be lost or destroyed without the fault of the debtor and before he has incurred in delay. So walang magiging pananagutan class si debtor, may extinguish siya sa obligation, mapapalaya siya sa obligasyon niya, sa liability niya kung yung pagkawala ng bagay na yung class ay hindi niya kasalanan. Okay? Paano hindi niya magiging kasalanan? Maaaring nawala ito dahil sa fortuitous event, those events that are beyond the control of the debtor class. And another consideration para masabi natin na extinguish talaga siya sa obligation class is that he has not incurred in delay. Meaning to say, hindi pa delayed yung pagdi-deliver niya sa bagay na yon, sa determinate thing na yon or specific thing. For example, tomorrow, yun yung intended delivery ng determinate thing na yon, nawala siya today. So, hindi pa siya delay class kasi bukas pa naman niya i-deliver eh. So, nasa possession pa niya, nawala, no? So, hindi siya liable for that, and she or he can be extinguished from the obligation. But it's another story class kung nawala yung bagay na yon na nakapag-incur na ng delay si debtor. Halimbawa, ngayon ang delivery niya, hindi niya na-deliver. Bukas pa niya na-deliver. Okay? So, nawala yung bagay na yon bukas, no? So, incurred na siya ng delay, kasalanan pa niya, kaya nawala. So, magiging liable na siya. Basta tandaan lang na pag hindi pa siya delayed, no, at nawala yung bagay na yon because of fortuitous event, no, may extinguish siya sa obligation. Pero kung delayed na, okay, ay pwede na siyang managot class, no, mananagot siya for the loss. So, second paragraph, when law or stipulation, the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. Okay. So kung maninaw class na nakalagay sa batas, clearly stipulated sa contract or agreement of the both parties that even in the cases of fortuitous event, still mananagot si debtor, then hindi siya pwedeng ma-extinguish obligation kung nangyari nga yung fortuitous events na yun kasi duly stipulated and clearly stated sa batas. So the same rule applies when the nature of the obligation requires the assumption of risk. So kung meron talagang risk na involved dun sa obligation na yun class, so i-bear ni debtor yun. And kung ano man ang mangyari, no, kahit pa fortuitous event, ang dahilan ng pagkawala ng bagay na yun, dahil nga kasama na talaga sa obligasyon niya yung risk na yun, then mananagot si debtor. So, ang isang obligasyon na binuo ng paghahatid ng isang tukoy na bagay ay dapat wakasan kung ito ay mawala o malipol na walang pagkakasala ang may utang at bago siya makapag-antala. Kapag nasa batas o estipulasyon na ang obligor ang mananagot maging sa mga di inaasahang pangyayari, ang pagkawala ng bagay ay hindi makakapagwakas ng obligasyon at siya ang mananagot sa mga pinsala. Ang parehong tuntunin ay mailalapat din kung ang likas na katangian ng obligasyon ay humihingi ng palagay ng panganib. So Article 1262 of the New Civil Code speaks of the following requisites, no? Requisites to free the obligor or debtor from liability. So kailan natin class masasabi, no, na mapapawalan na natin sa obligasyon si debtor. So kailangan present itong mga requisites na to. So una, obligation is a determinate thing. So yung i-deliver ni debtor class or ni obligor ay dapat specific thing, determinate thing. So kung sasakyan yan, nakasaad doon kung anong plate number, chassis number, no? So specific, determinate. Pangalawang requisite, loss is without the fault of the debtor. Kailangan ang dahilan ng pagkawala ng bagay na yun ay hindi kasalanan ni debtor. Ito ay dahil sa fortuitous event. So, pangatlong requisite, obligor is not in delay. So, kung nawala yung bagay na yun na hindi pa naman talaga nakatakdang i-deliver, then, mapi-free sa obligation si debtor or si obligor. And then, last requisite class is, obligor is not in bad faith. Meaning to say, wala siyang ginawang hindi maganda. Kaya, nawala yung bagay na yun. So, kailangan alagaan niya. No? So, sinasabi nga dito, in obligation to give a determinate thing class, the obligor has an added obligation to take care of the thing with diligence of a good father of a family. Otherwise, he is negligent. So, kung nasa iyo pa, no, the determinate thing is still in your possession, no, it is required from you to take good care of that as if you are a good father of a family. So, ariin mong sa'yo yan, alagaan mo na parang sa'yo. So, kung hindi mo magagawa yon, no, mananagot ka. Hindi ka ma-extinguish obligation pag nawala yun kung in bad faith ka. So, ulitin natin, the four requisites to free the obligor from liability are the following. Obligation is a determinate thing. Loss without fault of the debtor. Obligor is not in delay. And obligor is not in bad faith. So, what do you mean by loss? So, when can we say, class, that what happened is a loss? So, we have at least 5 instances. First, the thing perishes. Second, the thing goes out of commerce. Third, the thing disappears in a way that its existence is unknown or cannot be recovered. Third, there is theft or robbery. Fifth, impossible because the thing to be delivered belongs to another. So, hindi mo na ma-deliver kasi intended pala siya sa ibang tao. No? Iba pala ang nagmamayari. So, note class that if the loss is without the fault of the debtor, he has the burden to prove his innocence. Okay, so kahit pa na ang dahilan pala ay fortuitous event, kailangan mapatunayan pa rin talaga ni debtor na inosente siya sa nangyari. So, burden sa kanya yon na, kumbaga, nakasalalay sa kanya ang pagpapatunay na wala siyang kasalanan dahil nawala yung bagay na yun. Okay, so let's proceed with delay. So, what do you mean by delay? So, delay is when debtor cannot deliver on the due date. Ngayon, ang delivery, kinabukasan pa niya na-deliver, delayed na siya, class. So, if after delay, the thing is lost due to fortuitous event, debtor is liable. So, tandaan lang, pag sumobra na tayo, lumagpas na tayo doon sa takdang araw na dapat i-deliver natin at nawala yun, no? Kahit pa dahil sa fortuitous event, we cannot use that as an alibi, class, no? As palusot para ma-extinguish tayo sa obligation. No, kasi nga, delayed ka na. You already incurred delay. So, what will be the effect of fortuitous event? So, fortuitous event does not necessarily extinguish the obligation to deliver a determinate thing. Hindi nangangahulugan na dahil nawala yung bagay na yon because of fortuitous event, ay agad-agad, no, ipe-presume natin, class, na extinguish na yung debtor sa obligation. No, tandaan, again, na kung delay or hindi. Pag hindi pa siya delay at nawala dahil sa fortuitous event, extinguish siya sa obligation. Pero kung delayed na siya, lumagpas na doon yung delivery or due date niya, no, at nawala kahit pa dahil sa fortuitous event, liable po si debtor. So it shall be extinguished, mawawala, mapapalaya siya sa obligasyon when the determinate thing shall be lost or destroyed without the fault of the obligor debtor and before he is in default. So tandaan lang class yung delay, kung always ask kung hindi pa ba delay or delayed na, so doon lang may extinguish ang obligation. So basta yung 4 kanina na requisites, kailangan present. Hindi po pwedeng isa doon, hindi nasunod. No? So dapat 4 na sunod class. So no exemption from liability for the debtor when the law so provides. So kung sinasabi sa batas na hindi siya makakatakas sa kanyang obligasyon, no? Sabi sa batas, then hindi natin mapapa-exempt class, no, si debtor sa kanyang pananagutan. Pangalawa, when the stipulation so provides. So kung sinabi nila sa agreement nila, sa contract nila, both parties, na even so, if there will be a fortuitous event, no, happened, ikaw pa din mananagot debtor. So kung may mga ganun stipulation class, then hindi natin extinguish obligation si debtor. And third, when the nature of the obligation requires the assumption of risk. So, by nature, may kaakibat talaga na risk yung obligation. Kaya, ang magbe-bear nun class ay si debtor. So, last, fourth is when the obligation to deliver a specific thing arises from a crime. Kaya ka nagkaroon ng obligation na ibigay sa tao, i-deliver sa tao ang isang bagay ay dahil nag-ugat ito sa isang crime, sa isang krimen. So the general rule class is that the thing loss or the loss of the thing is borne by the owner. No, ang kawawa dito class, no, ang kumbaga ang magso-shoulder pag nawala yung bagay na yon na hindi naman kasalanan ni debtor ay si owner or si creditor. Pero kung mapatunayan halimbawa ng owner o ni creditor na hindi, kahit fortuitous event yan, may negligence on the part of the debtor, no, mananagot si debtor. So, when the loss is due to robbery or theft, so paano naman kung ang pangyayari na pagkawala ay dahil sa pagnanakaw, no, panloloob. So, ano ang pwedeng gawin? So, debtor bears the burden of proof. He must show that he could not resist the violence. So, burden of proof pa rin on the part of the debtor. Kailangan mapatunayan niya talaga na wala siyang nagawa, no? Para mangyari para iwasang mangyari yung violence na yon. So, gusto lang natin ma-establish class na walang naganap na connivance, walang naganap na inside job, no? Something like that. Kaya kailangan niyang patunayan ng sarili niya. Okay, pangalawa, when debtor is liable for damages, debtor is liable rather for damages if he is negligent. May kapabayaan. Halimbawa, he placed the thing within the reach of thieves and not in secure or safe place. So, halimbawa, nilagay-lagay lang niya dyan kung saan-saan na pwedeng matukso ang mga dumadaan at kunin yon. So, negligence on his part. So, may pananagutan siya doon. Hindi siya nag-act as a good father of a family. So, bad faith siya doon, class. So, effect on reciprocal obligations. When you say reciprocal obligations, class, both parties are debtor-creditor on each other. So, first, the extinguishment of obligation due to loss or impossibility of performance affects both the debtor and the creditor. The entire juridical relation is extinguished. And last, the debtor must return to the creditor whatever he has received by reason of obligation. So, kailangan isole ni debtor kung ano yung na-receive niya kay creditor. Kung mangyayari itong extinguishment of obligation due to loss. So, let's move on, class, on Article 1263 and 64. So, for Article 1263, in an obligation to deliver a generic thing, or another term for that is undeterminate thing, the loss or destruction of anything of the same kind does not extinguish the obligation. So pagka ang nawala class ay isang generic na bagay, okay, hindi nangangahulugan, hindi pwedeng ma-extinguish obligation si debtor. Okay? Iba siya class pag specific na bagay. Kanina, diniscuss natin sa 1262, pag determinate thing at nawala yon na hindi kasalanan ni debtor, extinguish obligation. Dito naman, pag generic yung nawala, does not extinguish the obligation. Moving on, 1264, the courts shall determine whether under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. So, depende sa sitwasyon, tutukuyin ng mga korte kung ang bahagi ang pagkasira o pagkawala ng bagay ng obligasyon ay mahalaga para mapawalang bisa ang obligasyon. So sometimes class, ang nangyayari sa bagay na yon, partial loss lang. May parte lang na nawala, may parte lang na nasira. So it's for the court class to decide whether that injury, whether that loss is that important doon sa kabuuan ng bagay na yon to render that object not functional or ineffective. So court ang magde-decide noon. So yung nawala ba na yon o yung nasira, no? Hindi na ba magagamit yung bagay na yon? So dapat may decision coming from the court. So what would be the effect class of partial loss of a specific thing? So let us define first what is partial loss. So partial loss when only a portion of the thing is lost or destroyed, or when it suffers depreciation or deterioration. So partial loss is the equivalent of difficulty of performance in obligation to do under Article 1267. So deterioration, pagbaba sa value. Okay? So, etong partial loss ay iahambing natin or kasing bigat siya class nung or equivalent siya ng difficulty in performing something. So, minsan may prestation class na mahirap nang gawin kasi that would mean danger on your end, no? That would mean sacrifice on your end. So, as if meron ng partial loss of the obligation. So in this case, no, in this case of partial loss, the court is again given the discretion. No, nasa kanila, sila may say, mga korte, in case of disagreement between the parties to determine whether under the circumstances it is so important in relation to the whole as to extinguish the obligation. In other words, the court will decide whether the partial loss is such as to be equivalent to a complete or total loss. So sila ang magtatakda kung yun na wala na yun, nasira na yun, ay that would render the entire thing, no, ineffective or not functional anymore. So example, Gloria obliged herself to deliver to Joseph a specific racehorse. So a horse met an accident as a result of which it suffered a broken leg. The injury is permanent class. Here, the partial loss is so important as to extinguish the obligation. So since the purpose of the horse is for racing at yung gagamitin niya para makatakbo siya ay nawala, nasira na, okay? So that would render the entire horse ineffective and that would render the obligation extinguished. No? So, kung yun ay walang mali si Gloria, ha? But what if may kasalanan siya? So, paragraph 2 or sentence 2, statement 2, if the loss is due to the fault of Gloria, she shall be obliged to pay the value of the horse with indemnity for damages. So, kung mapatunayan ni Joseph na may kasalanan dito si Gloria class, no? Magbabayad ng halaga ng horse na yon si Gloria plus pwede pa mag-file ng action si Joseph, no, for indemnity, no, yung mga damages. Second example, if the horse to be delivered is to be slaughtered by Joseph, pangkatay lang naman, the injury is clearly not important. So kung pangkatay lang yan, kahit na nabalian pa ng paayan, okay, hindi naman mahalaga kasi anyway, kakatayin mo rin naman. So even if there was fault on the part of Gloria, she can still deliver the horse with liability for damages, if any, suffered by Joseph. So hindi pwedeng singilin ni Joseph Class si Gloria ng halaga ng kabayo. Kasi nga, itatakda ng korte na Joseph, hindi naman na mahalaga kung nabali yung paan ng kabayo. Anyway, kakatay mo rin lang naman. So kung meron kang may incur na damages dahil nga sa nangyari na yun, ang pagkabali ng paan ng kabayo na yun, then pwede mo na lang singilin yung kay Gloria. But never na yung value ng horse na yun ay sisingilin natin kasi iba naman na naging purpose mo. Hindi mahalaga, no? Hindi importante, no? Yung nangyari para mawala ng saysay yung bagay na dineliver sa'yo. So that is, or those are rather the effects of partial loss of specific thing. Article 1265, whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault unless there is proof to contrary and without prejudice to the provisions of Article 1165. So ipagpapalagay natin class na kasalanan ng debtor pag nawala yung bagay na yun na i-deliver niya habang nasa possession pa niya. Pwera na lang kung merong patunay na hindi niya talaga kasalanan. So this presumption, yung pag-iisip natin na kasalanan niya talaga, na ang pagkawala, hindi natin pwedeng i-apply kung nawala yung bagay na yung class because of natural calamities. Ano-ano yun? Earthquake, flood, storm, or any other calamities. So kung oo nga, ipagpapalagay natin na kasalanan dapat kasi nasa possession niya. Pero hindi applicable yun class kung dahil sa natural calamities. Nawala yung bagay na yon na nasa possession pa ni debtor. So kapag ang bagay ay nawala sa mga kamay ng may utang, ito ay inaakalang nawala dulot ng kanyang pagkakamali. Maliban na lamang kung may makakapagpatunay sa taliwas nito nang hindi nakakapinsala sa probisyon ng Artikulo 1165. Ang samantahang nabanggit ay hindi maaaring gamitin sa mga kaso ng lindol, baha, bagyo, o anumang natural na kalamidad. So the article establishes a disputable presumption of fault whenever the thing to be delivered is lost in the possession of the debtor. So malaking usapin talaga class pag nawala yung bagay na yon na nasa possession pa ni debtor. So this presumption is reasonable because the debtor who has the custody and care of the thing can easily explain the circumstances of the loss. The creditor has no duty to show that the debtor was at fault. So, hindi na kailangang patunayan pa kung ito ay dahil sa natural calamity class. So, ipe-presume natin na walang kasalanan dito si debtor. So, under the third paragraph of Article 1165, I don't know kung naalala niyo pa yung previous lesson natin, na-discuss na natin ito. Ang sinasabi sa third paragraph of Article 1165, the obligor who is not at fault is still liable in case he is guilty of delay or has promised to deliver the same thing to two or more persons who do not have the same interest. So kung, oo nga, dahil sa fortuitous event, kaya nawala yung bagay na yun, but magiging liable pa rin siya class kung delayed na siya at nangako pa siya na i-deliver yung same na bagay na yun sa dalawang magkaibang tao na meron ding magkaibang interest. So liable pa rin siya. So in case of natural calamities, lindol, bagyo, baha, the presumption of fault does not apply. Tandaan, hindi natin pwedeng isipin na kasalanan ni debtor pag dahil sa natural calamities. So lack of fault on the part of debtor is more likely. So it is unjust to presume negligence on his part. So hindi tama class, hindi makatarungan na isipin natin na kasalanan ni debtor kung nawala yon dahil sa natural calamities. Okay, so for a moment class. Okay, let's have an illustration. So Ben borrowed the car of Bon. On the due date of the obligation, Ben told Bon that the car was stolen and that he was not at fault. So that is not enough to extinguish Ben's obligation. So it is presumed that the loss was due to his fault. Hence, he is liable unless he proves the contrary. Nanghiram siya ng sasakyan kay Bon. Nung oras or araw na isusoli na niya, nawala yung sasakyan. So sabi niya, hindi ko naman kasalanan kaya nawala yun. So hindi ganun kadali yun, class, ha? Ben should prove his innocence, no? Kasi ina-assume natin, pinipresume natin, sabi sa batas, na pagka nawala ang isang bagay sa possession pa ni debtor, ito ay kasalanan niya unless he proves the contrary. Suppose naman, halimbawa, same example, nanghiram pa rin si Ben ng sasakyan ni Bon. Pero ito naman ang circumstances, class. Suppose the house of Ben was destroyed because of earthquake. It is admitted that there was an earthquake and it was accidental and that the car was in the house at the time it occurred. Here, Ben is not liable unless Bon proves fault on the part of Ben. So, nasira, nadama yung sasakyan dahil nagkaroon ng lindol. So, walang pananagutan dito si Ben. Puwera na lang uli, except kung merong patunay si Bon na merong negligence on the part of Ben. So, kung mapapatunayan niya yun, na, halimbawa, class, meron naman sana nagawa si Ben para maialis yung sasakyan doon bago magkalindol. Halimbawa, nagkaroon ng warning, nagkaroon ng pagsabi si Bon na, okay, instead na isoli mo yan sa akin ngayon, no? Or bukas, pwede bang i-safety mo na muna yung sasakyan kasi nabalitaan ko may lindol, ilagay mo siya, i-park mo siya somewhere na walang pwedeng bumagsak or whatsoever. So kung umuo si Ben doon, nag-agree siya pero hindi naman niya ginawa. So maaring gamitin yun ni Bon at kung napatunayan niya to sa korte at tinanggap ng korte yung kanyang proof na yon, no, mananagot pa rin si Ben kahit na natural calamity, class ang naging dahilan ng pagkasira, no, nung bagay na yon. So Article 1266, the debtor is in obligation to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obligor. So kung ang prestasyon, no, yung ipe-perform na bagay ay legally impossible na, physically impossible na, papalayain din natin, i-extinguish din natin siya sa obligation. So, ang nagkakautang sa obligasyong pagganap ay marapat din namang pawalan sa kanyang obligasyon kapag ang obligasyon ay naging legally or physically impossible nang walang kasiraan mula sa nagkakautang. So this article applies only to obligations to do, no? Hindi po pwedeng i-apply itong Article 1266 sa ibang prestations, class, gaya ng to give and not to do. Ito ay applicable lang uli, no? Again, sa to do. To extinguish the obligation, the prestation which the debtor is supposed to personally perform must have become impossible of performance after the execution of the contract. Tapos na nilang magawa yung contract, pero naging imposible nang gawin pa nila yung prestation na yon na to do dahil may lalabagin na batas, legally impossible na, and hindi nakakayanin pang gawin dahil meron ng mga physical hindrances. So otherwise, if the impossibility existed from the inception of the contract is void and logically there will be no basis for the obligation, no? Obligation to do. So ganito, so habang binubuo nila yung kontrata, nag-uusap sila, pero alam naman na nila na legally or physically, no, imposible naman nang magawa yung prestation na yun doon sa contract. No? Ano ang magiging effect nun? The contract is void. Meaning to say, from the very beginning, class, the contract is not valid. No? Therefore, walang basehan para sa obligation to do. So this article also contemplates two kinds of impossibility. As we have mentioned, legal impossibility and physical impossibility. So legal impossibility arises when the act stipulated to be performed is subsequently prohibited by law. So yung napagkasunduan natin, hindi na natin pwede pang i-perform yon, gawin yon kasi meron na tayong lalabagin na batas. Example, Shakespeare agreed to construct a 32-story building rather for Hamlet. Before the construction could be started, a law was passed limiting the construction of structures in the area up to 10-story for purposes of safe aviation. the constructor is released from his obligation. So partial release lang ito, class, kasi ang una talagang nasa contract nila ay 32-story. It's just that, nung sisimulan na yung pagtatayo ng building, may naipasang batas na hanggang 10 story na lang ang pwede sa area na yon, no? Para sa safety ng mga gumagamit ng himpapawid doon, no? Mga lumilipad na kung ano man yun dyan, aviation. So, hindi na pwedeng sundin yung 32. So legally impossible na. May masasagasaan na tayo na batas, no? That would be unlawful, no? Then partial extinguishment lang mangyayari. Hindi ka na nga magtatayo ng 32, but you are still required to perform, no? Kahit 10. So nasa usapan naman yun, plus kung sakali, no? Ayaw na halimbawa nung may-ari na going back, class, so nasa pag-uusap naman yan ng contractor at saka ng may-ari kung itutuloy pa rin yung hanggang 10 or totally i-abolish na lang yung contract, no? Wag na lang at all. So nasa kanila naman yon. So but then again, that would be legally impossible to construct 32 because that would be against the law. How about physical impossibility? Arises when the act is supposed to be performed by the obligor due to reasons subsequent to the execution of the contract. Could not be physically performed by the obligor. So, imposible na niyang gawin yung prestation to do dahil physically, wala na siyang magamit na parte ng kanyang katawan para gawin yung bagay na yun. Halimbawa, Da Vinci has agreed to paint the countenance of his client, Mona Lisa. After the execution of the agreement, Da Vinci was involved in a car accident resulting in the amputation of his hands. The prestation has thus become physically impossible to perform. Subsequently, the painter is released from his obligation to paint. So, you see, gagamitin niya kasi yung kanyang kamay, paano pa siya magpipaint kung naputol na ang kamay ni Da Vinci? So, extinguish na siya sa obligation to paint. So, ito yung mga sinasabi natin na impossibility, legal impossibility, hindi mo na masusunod yung performance, no? Hindi mo na mapo-perform yung prestation, gawa ng meron ka ng lalabagin na batas, and another reason, hindi mo na magagawa dahil imposible na dahil wala ka na magamit na parte ng katawan mo para ma-perform mo yung prestation. So, ito yung sinasabi na impossibility. So, mamaya, dito sa next article, moral impossibility naman. So, when the service, according to 1267, when the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. So, kung masyado ng delikado, mahirap gawin yung bagay na yon, pwede din nating ma-release sa obligation class, ma-extinguish yung tao na yon. So, pwedeng buo, mapawala siya sa obligasyon, or partial. So, effect of difficulty of performance, the general rule is that impossibility of performance releases the obligor. Either yung kanina, legal, physical, impossibility, so ma-extinguish siya sa obligation. So this is also referred as doctrine of the frustration of the commercial object or frustration of enterprise. This article refers to moral impossibility or impracticability due to change of certain conditions. So note, class, that this article speaks of service. Service is a personal obligation and not a real obligation, which is to give. So example, Victor, together with other construction workers, agreed to construct a road near a mountain. A hurricane caused landslide, making the construction of the road dangerous to human lives. So in this case, Victor may be released in whole or in part from his obligation to continue with the construction. So dahil sa certain conditions na yun, pwedeng mapalaya sa obligasyon, buo or partial yung tao na yun. Kasi that is a moral impossibility. Paano mo pipilitin ang tao na gumawa kung ito ay mangangahulugan na ng kapahamakan ng buhay niya? Diba? So moral impossibility ang tawag natin doon. So in view of the non-construction of the road, the failure to grind sugar does not give rise to damages. So dahil hindi natuloy yung pag-construct ng road, maraming negosyo halimbawa ang naapektuhan. So itong mga hindi nila na commit itong mga negosyo na to kasi hindi nila pwedeng ipataw no kay Victor 10 ng kanyang mga kasamahan. So dahil ito ay morally impossible. So 1268, when the death of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause rather for the loss, unless the thing having been offered by him to the person who should receive it, the latter refused without justification to accept it. So, kung meron kang obligasyon na magbigay ng isang bagay sa isang tao dahil nag-ugat ito sa ginawa mong krimen, kung mawala man ang bagay na yun, plus, kahit pa sabihin mo because of fortuitous event, still, mananagot ka sa presyo nun, sa value nun, plus damages. No? Pwera na lang, no? Kung tumanggi, no? Si creditor na i-accept yun. So, offer of payment, the debtor offers a payment, no? When the debtor offers a payment and the creditor refuses to receive it, no, anong pwedeng gawin ni debtor? So to consign the thing and thereby relieving himself from any responsibility for such thing. Remember our discussion last week, no? Incapacitated creditor to administer his property. So anong pwedeng gawin ni debtor para magbayad? So pwede niyang ibayad sa legal representative ni creditor or i-consign sa korte. So same in Article 1268, pwede niyang i-consign plus para mawala na siya ng obligasyon. Second, pwede naman niyang i-keep no, in his possession with due diligence subject to general rules of obligation. So let's have an example. Daniel stole Charity's watch. Daniel has the obligation to return it to Charity. The obligation of Daniel arises from an act punishable by law. So kaya nagkaroon ng obligasyon si Daniel class na ibalik yung bagay na yun dahil ninakaw naman niya yun, punishable by law. So even if the watch is lost without the fault of Daniel, ninakaw, after niya manakaw, nawala naman sa kanya. Hindi naman niya kasalanan yung pagkawala, but he shall be liable for the payment of the price of the watch. The exception to the rule is when is charity in mora accipiende. Either case, Daniel is liable if the loss is due to his fault. So what is mora accipiende or mora of the creditor? So this is the delay of the obligee or creditor to accept the delivery of the thing which is the object rather of the obligation. So pag merong delay, merong pagtanggi sa part ni creditor, natanggapin no, yung ino-offer, yung dinideliver sa kanya ni debtor. So Article 1269, the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third person by reason of the loss. So kung ano man ang meron na rights si debtor sa third person dahil nagkaroon ng pagka-extinguish ng obligation because of loss, mapapakay creditor po lahat ng karapatan. So kapag pagkakatiwala ang napagkasunduan, ang nagpapautang ang may karapatang bumawi sa nangutang, maaring mawala sa kanya ang karapatan sa anumang kagustuhan niya sa bagay na ito. Ang kanyang mga kasamahang nagpapautang, mga gumagarantiya at mga tagapanagot ay magiging malaya. So we are now in section 3, condonation or remission. Okay, so what is condonation? So ito rin class, section 3, dahilan din para ma-extinguish ang obligation. So condonation is implied forgiveness. Pag sinabing implied, hindi tahasan na sinabing, okay, pinapatawad na kita sa obligasyon mo. Hindi niya tahasan sinabi yon, but yung kanyang actions, yung kanyang kilos, somehow, magpapakita na ikaw ay na-forgive na niya. So we call that condonation. Remission naman is a release from a debt or claim. Maybe by will. So ito naman nakasulat, naka-document, okay, remission. So these two are gratuitous abandonment of the creditor of his right against the debtor. So this is also a form of donation in a negative form. debtor is freed from obligation to make payment and delivery. Pinalaya na ang debtor sa kanyang obligasyon na magbayad o mag-deliver. So kinds of remission, it can be expressed or implied. Expressed pagka sinabi, verbally, or in writing. No, obviously, makikita natin, no, malalaman natin na nire-remit na niya ako dito. Ibig sabihin, pinapawalan na niya ako sa obligasyon. So, or kaya implied, gaya ng sabi ko, can be inferred from conduct, yung kanyang gawa, kanyang kilos. Another kind is complete or partial remission. Mapapawala ka sa obligasyon, buo na obligasyon, or partial lang, portion lang ng obligation na yon. Note class that express remission must be judicial in the form of a stipulation subject to court approval and must follow the formalities of donation. Ano ba yung formalities of donation? So pagka we are talking about property class, if it is exceeding 5,000, it should be in writing for the donation to be valid. So examples, if condonation or remission involves real property, no, it must be in public instrument. Ibig sabihin, notaryado yung condonation na yun or remission. The specifications describing the property and its encumbrances must also be stated and accepted in a public instrument and made known to the donor. If condonation or remission involves personal property, ito naman, halimbawa, mga sasakyan o kaya alahas. Yung real property kasi ito yung mga immovable property. So kung ang involved ay personal property, may be done verbally upon the return or delivery of the thing and or in writing with due acceptance in case property exceeds 5,000. Fourth, confusion or merger of rights. So the obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. Nagsanib na class ang katauhan ni debtor at creditor sa iisang tao. Halimbawa, ikaw dati yung may utang, nagkaroon ng chance, no? Nag-iba ng sitwasyon, yung utang mo, ikaw na rin ngayon ang naging creditor. So kung anumang dahilan, pasa-pasa halimbawa ng utang, no, tulakan ng utang, yung utang mo, napunta na rin uli sa'yo, ikaw na maniningil sa sarili mo, so paano mo sisingilin sarili mo? Oy, sir, bayad ka na, no? Kasi ibabayad ko yan sa akin, no? So parang ano naman, awkward naman class. Kaya kung may mga ganong pagkakataon na nag-merge yung katauhan ni debtor at creditor, nawawala ang obligation, no? Na-extinguish. Kaya ito yung section 4, confusion or merger of rights. So ang obligasyon ay walang bisa mula sa oras na ang anyo ng may utang at nagpautang ay maging iisa sa isang tao. So confusion or merger of rights is the meeting in one person of the qualities of the obligee and obligor with respect to the same obligation. The characters of the creditor and debtor are mixed in the same person. It is nonsensical for the said person to push or pursue a claim against his own self. The merger results to the extinguishment of obligation. So what do we mean by merger? So it is the meeting in one person of the qualities of creditor and debtor with respect to the same obligation. So guarantor is a person or an organization that promises to pay a debt owed by a second person if the latter fails to repay it. So careful kayo class pagka kinukuha kayong guarantor kasi ang magiging role nyo dito class, responsibility nyo, in case na hindi magbayad yung second person o yung tao na originally may utang, kayo po ang babalikan ni creditor. Kayo, the creditor will run after you. Okay, so section 5, the last section, compensation. Compensation shall take place when two persons in their own right are creditors and debtors of each other. So, si A, debtor-creditor ni B, si B, debtor-creditor din naman ni A. So, parang class, nag-quits na lang. May utang ako sa'yo, ikaw rin naman may utang sa akin. So, i-compensate na lang natin ang sarili natin, extinguish ang obligation. So, yun ang compensation. Ang kabayaran ay mangyayari sa dalawang tao ayon sa kanilang mga karapatan kung sino ang nagpautang at sino ang umutang. compensation is the extinguishment to the concurrent amount of the debts of two persons who, in their own right, are debtors and creditors of each other. So we have here the kinds of compensation. First, by its effect or extent. Second, it can be total when both obligations are the same amount. Utang ko sa'yo, 5K. Utang mo sa akin, 5K. Compensate na lang natin, extinguish ang obligation natin sa isa't isa. Okay? Kasi parehong amount. Partial naman when the obligations are of different amounts. Utang ko sa'yo, 10K. Utang mo sa akin, 5K. Mag-compensate tayo hanggang 5K. May utang pa rin ako sa'yo na 5K. Partial ang tawag doon. Fourth, by its cause or origin. Ano ang dahilan? Bakit nagkautang tayo at nagkaroon ng claim sa isa't isa? Fifth, legal, when it takes place by operation of law, even without the knowledge of the parties. Sixth, voluntary, when it takes place by agreement of the parties. Seven, judicial, when it takes place by order from a court of litigation. And eight, facultative, when it can be set up only by one of the parties, meaning it's either the debtor or the creditor. Let's have an example to that. Chowquin owes McDonald 10 million. McDonald, on another occasion, owed Chowquin 15 million pesos. So McDonald is liable to Chowquin with 5M. Why 5M? Magko-compensate sila up to 10M plus. Dahil mas malaki ang utang ni McDonald kay Chowquin, kailangan pa niya magbayad ng additional na 5M. Nag-compensate sila sa 10M, another 5 para ma-extinguish siya sa obligation niya kay Chowquin. So in order that compensation may be proper, it is necessary therefore that each of the obligors be bound principally and that he be at the same time the principal creditor of the other. Ibig sabihin si A, principal creditor kay B, ganun din si B. Principal creditor din siya kay A. So, that both debts consist in the sum of money. Dapat pareho ang utang, no? Parehong pera o kaya parehong, kumbaga ito, parehong consumable. They be of the same kind and also of the same quality if the latter has been stated. Third, that the two debts be due, that they be liquidated and demandable. And then lastly, that over neither of them there be any retention or controversy commenced by third persons and communicated in due time to the debtor. So that concludes our lesson for this afternoon class. So thank you so much for your attendance, for your participation. So thank you so much everyone for attending and participating into this discussion. So I appreciate your attendance and hope to see you again next week. So with that, thank you and God bless everyone. Bye!